Ron from Ronald Rohde Law, and in this video, we're going to walk through an industrial asset PSA and joint escrow instructions. Stay tuned. All right, guys, Ron from Ronald Rohde Law, and we're going to talk about a really important purchase and sale agreement. This is for an industrial asset. This was actually used for a flex property, but it's really applicable to any type of building with multi-tenants, turnover, that sort of thing. This is a seller-friendly agreement, so there's going to be a lot of seller protections, totally capable of being revised. But I'm going to also post another one shortly that is more buyer friendly, but this one is definitely seller friendly. So if you're looking for some current clauses, watch this video and we'll find out more. All right, kind of the opening instructions. I think it's always important to do the PSA plus binding instructions on the title company, right? You want them as a party to this contract because they're in charge of some critical earnest money, and there always are issues. So if we need to sue for breach of contract, we have this agreement that governs the title company as escrow agent. Seller, buyer, pretty straightforward. Again, recitals, certain real property and improvements. This is something I talk about, the real property plus now a lot of the intangible intellectual property, the names, the phone numbers. Less so on industrial, but more so important on multifamily. So photos, apartments.com listings, trade names, websites. If they've got a great website that you want to keep, at least keep that traffic and route it to your new website. So buyer, broker, you may have a broker here, attorney, closing date, 15 days after due diligence, deposit here. So they put $200,000 down, which is pretty normal for the purchase price. 45 plus a 15-day close. And then they have an automatic extension at the election of the buyer. So again, I think we're seeing that more common. We're seeing kind of a shorter optimal close and then pre-negotiated extensions into the contract, and it's really nice to give that buyer a buffer, and they just know contractually they can extend for an additional earnest money deposit. Whether that's hard or not depends on you. Identify the escrow holder here. It's usually your title company here. All the improvements, laws, leases, permits, permitted exceptions. So here, personal property, we start to expand these logos, marks, signage. There's really a lot. URL, domain names, social media accounts. That's what I was talking about. May have a Facebook page. Google My Business. Very useful for driving tenants, especially on the multifamily side or consumer based. Purchase price, seller, title company. Usually this is the same, right? So this title company will be the same as the escrow agent, usually. Deposit 2 days, pretty quick. Sometimes I see 3 on most of my other stuff. Independent consideration, that's kind of like a Texas thing, so not always useful in other countries, other states. Alrighty. Guys, apologize. It's Friday. I've had a long week. I'm really looking forward to the weekend, so any stumbling that I do is my error alone. Closing date here. So here we have the extension option, 2 business days prior to the initial closing date and a 30-day extension. So that's pretty generous, which if I recall, this transaction was taking place in the holidays, and a 15-day extension really just didn't help. We needed a full 30, but we're able to get this one closed with that extension. Covenants, these are all the seller's obligations. They'll do a bring down certificate, title report. This is pretty normal. This is extended title review period. So you definitely lay out each of the periods when buyer can object, seller can respond, and then a deadline for the buyer to respond, and then the seller response. So it's a little bit more in depth here, but it's nice. I like having that extra structure. And so we have deadlines for each party to just keep the ball moving back and forth with real deadlines, as opposed to letting one party sit and just kind of wait without any pressure to move forward. Title insurance, T1, again, pretty standard, but this has just a lot of clarification and a lot of identity of who is supposed to do what and what is included and what's not. Survey, deliver existing, otherwise the buyer is going to have to pay for a new one. 48 hours notice, sometimes it's 24 if it's buyer friendly. That's an easy area. Returning the property to original condition, any boring holes, that's not always listed. I think a lot of people do that, but this is just very explicit in terms of what you have to do to restore the property. Insurance, $2 million maybe is kind of high. Usually maybe it's $1 million, but for this property price point, I think it's totally reasonable. Indemnification for any agents or inspectors that come on property, totally normal. No reliance, this one is tough. Sometimes we modify this for the buyer. They can put some responsibility or representations or warranties on the seller for documents that they provide. Here we have due diligence and tenant interviews. Interview the tenants, and seller will have the right but not requirement. Termination notice, again, if you are going to terminate and want your earnest money back, it's critical that you understand everything in this paragraph and that your lawyer complies with it to the T, because I guarantee you when you're doing these big transactions, technical mistakes that are worth $200,000, the other side will jump on it. They will jump all over you and they'll keep it and they'll say, sorry, that's just business, but we got to keep your money. 3 days to provide contracts, and seller will provide notice of termination, otherwise they're non-terminable. Again, it's just a lot of detail about what needs to be expressly approved and assigned versus seller give notice of termination. These are typically like your month-to-month contracts, the disapproved, and then non-terminal will be something more long-term, like maybe an energy contract. And so it's just up to the buyer to understand what is out there in terms of executory contracts, right? These are contracts that are not recorded. So you have no other mechanism of knowing what is bound to the property, because they're not going to come up on a title search. Escrow Matters, closing costs, 1/2. Again, this is pretty normal. Sellers, attorney's fees, 5,000 credit. Okay, so this one they actually did pay for some, causing it to be recertified. Commissions, buyers pays 1/2. Apportioned as of normal. These are all your seller obligations. And again, I think it's really important to include all of these documents as form of. So you have an opportunity to actually see the form of the special warranty deed, the form of the notice of tenant, because you don't want to get into the contract and then you start to have a disagreement about what should be in an estoppel certificate, what should actually be in the deed. It is in the PSA, and all you have to do is fill in the parties' names at closing. Buyer obligations here, sign the notice, provide information to cooperate. That's all pretty normal. Prorations. We spend a lot of time here, prorations, adjustments. It's not like any other property. I think that because there are fewer tenants that are writing bigger checks, if you have disputes or you have late payments, it can be a significant amount of money, right? We're not talking about, say, like a multifamily where, let's say you close on the 15th of the month, most of the tenants are going to be paid. If they have a high collection rate, they're going to collect 90%, 95% in the first 5 days, maybe 96% in the first 10 days, 12 days. So you close on the 15th, it's going to be a pretty even proration, and you're just missing a few percentage of revenue. It's not a big deal in terms of the absolute dollar amount. However, in industrial, you have much fewer tenants and they're writing big checks. And so let's say you have a building with 4 tenants at $25K each month. If one of those guys has a dispute or he's late for whatever reason and you close on the 3rd, he may not pay, and you really want to make sure that you get that money prorated or you get it back, or you have some understanding of what the proration should be post-closing for buyer obligation to remit those funds for the prorated time. So again, just because it's a bigger amount and depending on when you close in the month, so you need to have these paragraphs to understand how to apportion additional rents, late payments, back rent owed for time that the seller owned the property, that sort of thing. And then at some point, right, it becomes the buyer's property, and even if a tenant becomes current for amounts owed 6 months ago during COVID, that just becomes the buyer's money. It's just that simple. At some point, you draw a line, and you say any money collected is non-collectible. Here we go, renewals. You really want to be clear about what you want the seller to sign with your permission about the leases. And it can be a little bit tricky, right? Think about it from the seller's perspective. You want to run the building how you decide. That may include signing new tenants as they come up. Because you're not quite sure if this buyer is going to close, versus limiting your ability to require the purchaser to consent. If you're the buyer, you don't want them to sign a tenant that you don't love. If you don't like them, you don't want them to sign a tenant even if the seller wants to. And so you really have to be clear about when that transition occurs. There's maybe a handover. Typically it's going to be like after the due diligence expiration, which says, look, we can maybe notify you or maybe not. But if you're still in the due diligence, you may terminate and get all your money back. We don't want to be left out in the cold, not signing a tenant that the seller likes, because you may terminate. And on the flip side, the buyer says, well, after the due diligence period is expired, I'm committed. I'm in. This is essentially my building. I want control over the tenants that you sign. That's reasonable. But again, it really depends on your situation and the relationship with the seller about how you're going to handle the ultimate authority to sign leases. At the end of the day, the seller is probably going to say, it's my building. I'm not relying on a sale until it closes, which is a reasonable position to take. Disclaimers, buyer's side is no side agreements. This one is pretty big, right? This is a lot of buyer acknowledgement. I would strike this. I would cut this about a lot of the acknowledgments of the buyer that we may not know. And so I don't want my client to initial this if they don't have all of those understandings. And same for release. I'm not going to release the seller ahead of time for too much in advance. Seller's maintenance, substantially the same manner. We do get that a little bit where some sellers will start to use down inventory and they will not repurchase. Honestly, it's very hard to prove a sell down of inventory, but most people won't go out of their way to change their ordering, their resupplies. And again, you just want to look for a responsible landlord that is going to be in the industry, because as a buyer, you can tell if the inventory numbers drastically drop right before you take possession, and you're not going to want to do business with them in the future. So material event, we spent a lot of time on defining this threshold, $300,000. It's kind of high. I probably would like something closer relative to the purchase price, but if there's structural damage, and that could be as low as maybe $100,000 or $150,000, we maybe want to terminate because we don't know the extent of damage, and the buyer is kind of taking a risk. So putting more procedures about determining the contractors, the inspections, third-party inspectors to evaluate or estimate the price would be better suited for this type of situation. If it's immaterial, you got to close anyway. Termination, there you go. Again, representations, this is where you really want to make sure that they are providing all this, rent roll and the contracts, due diligence provided are true, correct, and complete copies. That can come out in litigation that later, oh, seller, you had this document and you did not pass it over to us, even though you actually had it. Seller representative, you want to make sure that person's a good person to identify, and it's not somebody too low level or too high level either. These are buyers representation by counsel. If you're not represented by counsel, I would strike these types of things and get a lawyer. Default, again, you want to limit their remedy to just taking the earnest money, not really forcing specific performance and going after you. No contesting liquidated damages. Buyer's remedy is specific performance. Waiver of trial, this is really favoring the seller, but AAA, that's fine. We're okay with arbitration. Just really depends on what your policies are as a client. Attorney's fees, notices. Again, I don't have much problem with these, except that we just need to read it and understand and make sure we comply. governing law of Texas, counterparts, electronic signatures. Sometimes people ask me, do any of these documents anymore have to be wet ink signed? And the answer is no, not for legal enforceability. That's solely going to be like a lender requirement or a private recording, but it's not a legal requirement for the contract and enforceability. No third party, independent counsel. I mean, look, this is just very, very detailed. I'm really, I like this contract. If I was a seller, I'd be happy to use this on any property. FERPTA limitations, 6 months here. So we have 6 months after the closing date, 50,000. This one had a really complicated structure of aggregate versus individual claims, and you couldn't bring a claim unless the aggregate was above the minimum. Estoppel certificates, again, it's attached as Exhibit F, so really important that you get to see it on both sides, right? The seller knows what they have to get from the tenant, and the buyer knows what they're going to receive. 1031 cooperation, pretty standard. Business day, state of Texas, no oral agreements and signatures and title. And then we have the exhibit list. I'll kind of skim through those. Form of special warranty deed, permitted exceptions, bill of sale for those personal property, assignments, contracts, assumption of leases, estoppel certificate. We talked about tenant notice letter, super critical, due diligence items. These are all provided by seller. And that's it. I kind of ran through this. Sorry, it's that Friday again. But this is a seller-friendly industrial PSA, and I hope it helps you guys out. So please smash that like button. Feel free to reach out or drop a comment if you have any questions about it. And we'll see you next time.